Good morning. I'm Gary DeWaal, and this is Bridging the Week for September 18th to 22nd, and today is September 25th, 2017. Last week, the Commodity Futures Trading Commission required a futures commission merchant to pay a fine of $2.5 million to resolve charges that it failed to supervise a response to a CME Group investigation when the FCM relied on analysis provided to it by an affiliate regarding the affiliate's block trades, and the analysis turned out to be misleading. Additionally, the CFTC expanded its footprint in the oversight of cryptocurrencies when it brought an enforcement action against two persons in connection with an alleged Ponzi scheme involving Bitcoin. However, the defendants did not purport to be involved in swaps or derivatives based on Bitcoin, solely Bitcoin. Days are getting shorter in the Northern Hemisphere, and fall is in the air. So I can enjoy the last few gasps of summer. Let's get started. Merrill Lynch Pierce Fenner & Smith Incorporated agreed to pay a fine of $2.5 million to resolve charges brought by the CFTC that from January through October 2010, the firm failed to diligently supervise responses to a CME Group market regulation investigation related to block trades executed by its affiliate, Bank of America N.A., on the Chicago Mercantile Exchange and the Chicago Board of Trade. The CFTC also charged Merrill, a CFTC-registered Futures Commission merchant, with failing to prepare and/or maintain certain records related to certain block trades, as required by Commission regulation, from at least January 2010 through June 2012. According to the CFTC, in response to various inquiries by CME market regulation, whether certain Bank of America personnel traded futures on CME Group's Globex electronic trading platform in advance of executing corresponding block trades, Merrill's legal and compliance staff relied on Bank of America's Business Operations Support Group to assemble relevant information and to communicate with relevant Bank of America traders as necessary. Market regulations inquiries were conducted from February 2008 and December 2010. Such advanced trading would have been impermissible prior to November 8, 2016. In response, said the CFTC, the Bank of America Support Group, which did not report to Merrill's or Bank of America's legal and compliance staff, provided Merrill's legal and compliance staff an analysis of the relevant trading that admitted showing, quote, that on a number of occasions, certain swap desk traders traded substantial volumes of futures contracts on Globex in the 5-minute window before the recorded execution time of a block trade in that same futures contract, end of quote. Bank of America Support Group allegedly knew this information, but kept it from Merrill's legal and compliance staff. Moreover, claimed the CFTC, Bank of America traders apparently did not admit to trading ahead during interviews conducted by market regulation staff during November 2010. CFTC charged that Merrill's legal and compliance staff reliance on Bank of America's support group without more closely monitoring its work contributed to Merrill's inability to detect the purported trading ahead before Bank of America's traders provided misleading information to CME market regulation and constituted a failure to supervise in violation of CME Group's rules. However, when a customer, even an affiliated account, provides documents and information to a registrant for further passage to a registrant, a regulator, it is acting as principal and the registrant is acting as agent. This case seems to have gotten that relationship wrong. I have more of my issues with the CFTC settlement order in this matter on the article version of Bridging the Week on the website. Check it out. Gelfman Blueprint Inc. and Nicholas Gelfman, its chief executive officer and head trader, were sued by the Commodity Futures Trading Commission for running a Ponzi scheme related to Bitcoin. According to the CFTC complaint filed in a federal court in New York City, from at least January 2014 through at least January 2016, the defendant solicited approximately $600,000 from at least 80 customers to trade Bitcoin in a pooled fund using a proprietary algorithm called Jigsaw. However, charged the CFTC, the defendants misappropriated most of this money for their own use and rarely traded for customers. The defendants furthered their alleged fraud claim to the CFTC by making false and misleading statements to potential and actual investors by, among other things, overstating customers' balances, falsely representing trading performance activity, and falsely representing past performance. The CFTC seeks a permanent injunction against the defendants, disgorgement and fines, as well as other relief. This CFTC complaint has ramifications far beyond its four corners. It represents a powerful statement by the CFTC that it will exercise jurisdiction over cryptocurrencies when there is potential fraud, even if the fraud does not involve derivatives based on the cryptocurrencies. I have more analysis and commentary on this on the website. Check it out. And finally, last week in a press release, innocuously headlined, quote, SEC Chairman Clayton issues statement on cybersecurity, end of quote, the Securities and Exchange Commission disclosed that last month it discovered that its electronic data gathering, analysis, and retrieval system, known as EDGAR, was hacked during 2016, and that persons may have profited from unauthorized information obtained through such intrusion. EDGAR, you may recall, is used by the SEC to collect submissions by companies and foreign governments required to periodically file certain information with it. The SEC noted, however, that it does not believe that the hacking resulted in the compromise of personally identifiable information. The SEC said that the hacking occurred through the test filing component of the EDGAR system and was patched promptly after discovery. Just last month, the SEC's Office of Compliance Inspections and Examination issued a report saying that while firms have, quote, increased cybersecurity preparedness, end of quote, since 2014, broker-dealers, investment advisors, and investment companies' cybersecurity policy and procedures are not uniformly tailored to their business because they are too vague or general and are not always followed or enforced. Moreover, the SEC has brought 2 enforcement actions against registrants for cybersecurity breakdowns over the past 2 years. The SEC's initiative regarding the development of a single consolidated audit trail, known as CAT, to track all equities and options trading on U.S. markets is well underway. Hopefully some valuable lessons learned from this SEC breach will be applied to the CAT governance and infrastructure. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.